Good morning, everyone. Happy Wednesday. My name is Irene and I'm here with Jane from Supporting Strategies. And today we're going to talk about a very specific topic, and this is geared specifically towards the home care industry in New York. Now, the home care industry is highly regulated, and we have seen both pre-pandemic as well as post-pandemic that the industry has been targeted with a lot of audits from both the Department of Health as well as the Department of Labor. And they're targeted both internally from a lot of their plans with the contracts that they have, as well as from government agencies. But today we're going to focus on some of those DOL audits that we've seen and what our clients need to be prepared for, especially within the home care industry for these audits. Now, what we recommend doing is taking a look at a sample set of employees in order to do an audit, a self-audit before the DOL comes in. And this is really recommended specifically to the home care industry because a home care agency would have a lot of employees all under one roof. And because of that, they become a big target. Instead of going to perhaps a smaller medical practice where you would have to have multiple medical practices to reach the number of employees that you might have under one roof in a home care agency, in one home care agency, typically there could be hundreds, if not thousands or tens of thousands of employees. And so the DOL would come in, and typically what they do is they would select a random number of employees. They already come with a pre-filled list of names that are available to them, and they ask for all the payroll records. They may ask for additional information as well about the shift, any clock in, clock out, etc. In order to get ahead of that, we always recommend every single year doing the exact same thing. You self-audit. Again, especially because these are such high-risk companies, given the number of employees that they have and how attractive they are to the Department of Labor for the purposes of audits, you really want to make sure that you're self-auditing. And so we recommend following the same procedure. You select a random sample of employees, and we recommend that that sample of employees is going to be no less than 5%. And then you begin to audit the sample of those employees. You would compare the number of hours that are worked to the hours that are paid. That would be for a wage and hour claim potentially. And in addition, because the home care industry has an additional payment known as wage parity that must be paid, you begin to check that the wage parity, which are payment for additional or supplemental benefits, was properly allocated and properly paid. Then what you do is if you find a certain number of damages, if we find that, we always ask for the same percentage of the staff that we've already audited, we ask for that same number of people to be given to us. So if we ask for 20 sample set, we ask for another 20 samples to be given over to us so that we can really check if two of the people had some violations in there. We really want to make sure that that was an isolated event. If it was not, and we find that it's 2 out of 10 that really have damages, we know that about 20% of our class probably has those same damages, since it's probably the same mechanism put into place for everybody. And from there, what we would do is we would extrapolate outward. Now, in addition for the home care industry, other than just the wage and hour claims, such as overtime and such as spread of hour claims that could come up, we've also had questions of break times and travel times. In addition to that, the Department of Labor has a new wage notice. So everyone in New York and every employer must give a wage notice to their employees. However, the wage notice specific to the home care industry or home care workers is the new LS-62 form. And that form actually requires information on the wage parity benefits, both additional and supplemental, to be listed there. It does need to be provided to employees like all other wage notices, either at the time of hire or before there's a change in any compensation. But the one difference here is that we used to be able to walk into these audits and certain benefits that may have been in one category or another category, we could either update it as we went along, or we could place them in those categories at the time of audit. Now, your wage notice, that LS-62 form, and how you've allocated those benefits must match to the same category at the time of audit. And it must be in the correct category as well. And there could be a potential violation for one or the other, either that it's not in the correct category to begin with and it was paid properly, or that it was in the correct category, but the problem is that it just wasn't paid as it should have been on the wage notice form. What this also does is we used to have a good faith argument, and we would say, well, this is what we thought we could do in good faith. Now that it's on the form, if it's not paid in accordance to what it says on the form, we really lose that good faith argument because we knew we put it on the form and we were the one that prepared it. So what we recommend doing is, because there is a period that the DOL can look back to 6 years, we always recommend starting at about 5% of the total employee staff number. And we recommend going back starting at 3 years. And then we recommend adding to that a certain percentage of employees from 4 years, 5, and 6 years. So the majority of the employees that we would be self-auditing would be within those, I would say, even 4 years. And that's really what we're most focused on, because that would indicate to us if there's a current problem, we need to fix that now before it continues forward. And it helps us really be able to also catch those violations if there's an issue. After we extrapolate out to the entire class, we at least know what our possible damages could be, because that's what the DOL does when they come in. They will not audit everybody, but when they assess violations, they will assess them across the entire class. Now, if we see rather high violations, one of the things we'd like to do is begin to ask our clients, what is their plan for repayment? And this is where you absolutely must consult with an attorney and an accountant to make sure that these repayments are being made appropriately. From the legal side, you need to make sure that if you have extrapolated, that you're not just paying everybody on the extrapolation method. That will not work on a repayment. You want to make sure that you are repaying based only on the amount that that employee is owed, and if there's any additional violation or penalty in addition to that, that's something that needs to be discussed independent on each employee. But you cannot pay the entire class one small sum. What will happen is some employees that may not have had any violations will be paid, and those that may have had violations will be paid too little. Something else to keep in mind is at the time of doing the self-audit, one of the benefits of what you can do is if there's a repayment, and there are programs within New York as well that allow a company to self-audit and submit that information to the Department of Labor, telling the Department of Labor, here is what we did, here are our results. And at that time, depending on what the plan is, it is possible, and it's very specific to the situation, so this is again something that must be reviewed with an attorney beforehand. It is possible that there may be a release for the claims paid, so that you don't have a situation where you've paid and paid additional violations and penalties already, and the DOL comes knocking anyway. So there's a couple of things to consider here. Are you alerting the Department of Labor after you did this good faith audit? That's one of the questions. Are you going to pay an additional premium in the event that you would like to see if you're eligible for a release of claims? Will you pay that additional compensation as consideration to receive that release? And is that even allowable in your circumstance? And also, if you find a considerable amount of the damages because of current policies, of course, the first recommendation is going to be fix the current policies, make sure that those are all updated, and that moving forward, at least you at least sustain a good faith argument on the basis of the fact that once you discovered there was an issue, now you have a good faith argument to fix that. What I'd like to do now is I'd like to ask a question of Jane for the purposes of the audit itself and the self-audit. So Jane, at the time of a company doing a self-audit, what documents would you require and what would be the process for that audit?
Okay. Hi, everyone. So as Irene was saying, we first have to establish the time frame for the payroll audit, and the DOL could go back up to 6 years. So this would be our first step. And then we would see, usually we would ask a client for the payroll company access, or at least being able to review some of the reports out of the system. So a helpful report would be, for example, like a report builder where you could view departments, dismissals, status of employment, and employment types eligible for overtime or salary. So we would review the employee data. So we want to make sure that everyone who's being paid is an active employee in the system, which listed correctly hourly rate, PTO information is accurate as well, right? So if somebody got a raise and we forgot to update it in the payroll system, that could be why we're getting sort of differences. We want to review hours worked and paid. So we want to verify hours worked against time cards, ensure that the employee hours worked are in line with the amounts paid. I think this is something that would be, when we spend most of the time on. Then we also want to check variable payment and different types of compensation. So overtime hours pay, commissions, additional wages, and supplemental wages that are applicable here. So typically the documents needed, right? We would want to have a list of all paid vacations, sick leave, and personal time used by each employee that we're looking at. Provide a list of employees who use the employer provided health insurance. We want to see a year-to-date payroll summary, which shows the total number of hours worked and wages paid broken out by regular, overtime, and service training, and time off for every employee. And we also want to see the payroll records for each employee, including the first day up to the last day, including the New Year's. And we want to provide it. We want to get a year of report of paid time off for every employee. So typically all the forms that we work are 941, which are quarterly reports, and 940 form, which is the annual report. And then if we're in New York State, right, we want to look at New York 45 report, also W-2 and W-3 forms, and payroll journal reports, time off balance reports, and the benefit deduction reports. If we were able to get all of these documents, we would be in a really good shape to kind of review all of this information. And, if we find any underpayments, if we're working and we're looking at the calendar year, so right now in 2022, so we're able to make a correction report payment in the payroll system up until the calendar year. But if we need to make any changes, we would have to do amended payroll reports. We have to do amended tax returns going back. And this is going to be a very specific situation in each case. So I hope that answered that, Irene.
Absolutely. Thank you so much.
All right. And I think this is this could entail more different further questions that we could cover later. So if you do have any questions, please feel free to reach out to us.
Thank you, everyone.